Let me tell you about the exhaustion theory that promises to overthrow the entire criminal traffic administration scam in our country. My name is David Toulis. I'm the investigative reporter and pro se litigant in Tennessee. And my thesis is that there are four elements, four bits of infrastructure in your law, in your state, just as in mine, that allow you a defense in traffic criminal prosecution. And the defense is under the main heading of the duty and doctrine of the exhaustion of administrative remedies. The state, according to the law, has a duty to exhaust its administrative remedies in pursuing grievance or allegation of wrongdoing under the privilege, which is the license. All licenses are administered in the same way. They're administered administratively in the board or in the commission that it issues a license and is responsible for it. And so my thesis is we can defeat criminal prosecution as out of step with the structure of the law that puts privilege management, privilege administration in the department responsible for the privilege. So in the use of a motor vehicle, the privilege is driving and operating a motor vehicle. That is a privilege. That's not done by right. It's a privilege, just like plumbing is a privilege, accounting, being a mortician, lawyering, surgery, podiatry, chiropractic. Those are all privileges in your state as in mine. So the 4 points, the 4 pillars of the overthrow of criminal prosecution in your state, starting with your case maybe, is or are as follows. Number 1, privilege. Where do privileges come from? Driving and operating a motor vehicle is your argument because it's a privilege. Driving and operating is a privilege. It is a calling, an occupation, and business that you have entered into by application in the payment of fees, and you pass a test, and now you are in the privilege, which is to say the trade and occupation of driving and operating in commerce. It's for commercial purposes. It's taxable activity. It's called revenue taxable activity to be in privilege. So that's number 1, privilege. Where does it come from? What is the basis of it in your state? It's in the Constitution probably. And that's the first point you have to understand. The second point is commissioner authority. Your DMV commissioner, your safety commissioner, the transportation commissioner in your state who's in charge of licensing and regulating traffic has a duty. He has authority and duty, and you'll find it in the provisions of law that create his department. He has a duty to handle disputes in the privilege. He has a duty to administer the law from the issuance of a license to the suspension or revocation, and all points between. All issues, great and small, are subject to his authority. These are not criminal matters. Why? Well, because of pillar number 3, the exhaustion of administrative remedies. The allegations against you for speeding or having a damaged taillight or going the wrong way down a one-way street, things like that, those are all privilege violations under equity. They're equitable things that are under the agreement that you accepted when you applied and agreed in the agreement to comply with the laws, which are the terms of the contract effectively. So you have a duty under the exhaustion of administrative remedies, or you have a right, I should say, under the exhaustion of administrative remedies to have the matter heard in the department responsible. And it's premature for the state to criminally enforce a administrative wrongdoing or allegation of wrongdoing. It's improper, and it uses the wrong police power. Administration of a license is economic police power, which has its own duties and rights. The commissioner has a duty to hear the state's claim against you, and you have a right to defend your innocence in front of the commissioner. So that's the thesis. It's in court now in Tennessee because people understand the issue. And the 4th pillar is UAPA, the Uniform Administrative Procedures Act. That is the body of law under which contested cases in the department are heard. UAPA, administrative procedures, controlling law, not criminal matters. These are civil matters, administrative.